Chapter 4. Violations.
So if the field investigator determines that there's a potential violation, they'll write a field report and send it into the central office where a compliance officer will look at it for evidentiary value and is it a significant enough violation to issue a fine, or would they issue a warning? And even if they issue a fine, if the contractor has a pretty good record of not having a bunch of violations, they'll work with them on the fine. And our goal really is compliance. It's not penalty.
CCB investigators uncover thousands of violations in the field every year. As of June 2019, CCB compliance officers were processing 201 open violations.
So some of the most common violations are not having a CCB license, and that's primarily what we're out there looking for. When we do come across licensed contractors that maybe are purposely trying to skirt the law, or maybe they didn't know that there was the certain regulation they need to be following, the violation would be not having active workers' comp insurance, which could be as simple as they let a policy lapse and they weren't aware of that. Or maybe not having the right endorsement. They're working on a residential and they're only endorsed to do commercial structures. Another violation is when they say that they're an independent contractor and they're exempt from workers' compensation laws, but in reality they have employees. Those are probably the most common violations that I see in the field. So if there's a violation at a job site check, I'm going to be there longer, ask more pointed questions. I still don't want to take up too much time of the contractor that's out there, but I still have a job to do. So I try to get to the point pretty quickly, but they are sometimes uncomfortable questions because they could potentially face a civil sanction from CCB. But the sooner that they're able to give me the answers, the sooner I'm able to move on. And then ultimately I'll write a report, and CCB compliance officer will decide if it warrants a violation, civil sanction, or a warning after I leave.
My name is Courtney Swagger. I'm a compliance officer for the Construction Contractors Board. So when a contractor gets a violation in the field investigator is going to build a comprehensive report. It will have pictures, permits, contracts, other various forms of evidence to support the alleged violations. Once the report is complete, he will forward it to a compliance officer in the office. A compliance officer will review the file, determine if the alleged violations are accurate, and then send out a notice of intent. With that notice of intent, the contractor will receive a notice response form, which is due 21 days from the proposed order. This gives the contractor to respond to the alleged violations.
So what happens when a field investigator finds a violation?
Once a field investigation report is complete, that report would be submitted to the compliance section. At that time, compliance would assign it to a compliance officer who would be handling the file, reviewing the allegations, and send the notice of intent. The notice of intent will have the alleged violations that was in the field investigation report, as well as any facts or supportive evidence that was provided at the time of the field investigation. We'll also have all the applicable statutes and rules that would support the violations.
What is a notice of intent? The notice of intent informs the contractor that the agency will be taking action, usually issuing a civil penalty. In the notice, you'll see an alleged violation, facts and supporting evidence, applicable statutes and rules. The response form is due within 21 days of the proposed order. How should you respond?
So there's numerous ways that a contractor can respond. We definitely encourage all contractors to reach out to the compliance officer once they receive that response form. Calling them and discussing the alleged violations, discussing the options is the best way to address the issues at hand. They can respond by email, fax, or they can mail in their response form. The first option is admitting to the violations at hand and agreeing to the full civil penalty or other disciplinary action. The second one is a settlement agreement, or requesting a settlement agreement acknowledging that you did in fact do the violations, but you're requesting a settlement. And then the third is requesting a hearing with the administrative law judge. After the notice of intent is sent, the contractor has three options to reply from that notice of intent. on that violation response form. If they admit to the violation, we would immediately send out a final order with the full proposed civil penalty or disciplinary action. If they requested the settlement agreement, that's when the compliance officer would be in discussions with the contractor and determine what best would be fit for that settlement agreement. And then we would send out a settlement agreement to the respondent in which the respondent would have to sign and acknowledge that settlement agreement in order for it to be compliant, so to speak. If we don't receive that response, we would send out the final order for the full proposed penalty or disciplinary action. If they request a hearing, the contractor will be sent contested case rights, and the hearing will be scheduled with the administrative law judge. Depending on the contractor's history, if there's been other violations, generally we will discuss the settlement agreement. At that point, the compliance officer will determine the extent of the settlement agreement for the violation, either suspending part of the penalty or suspending certain aspects of the violation, depending if there's a suspension and so forth, and then send out an amended settlement agreement, essentially changing the proposed order with the agreement that came between the compliance officer and the respondent. In a hearing, an administrative law judge will hear a representative from the contractors board and the respondent and go over the alleged violation. The contractors board will have the opportunity to provide documentation and evidence to support the violation that was proposed in the order, and then the respondent, the contractor, would have the ability to say their side and propose why the disciplinary action is not accurate. In hearing, their administrative law judge doesn't amend an order. He would either affirm or determine that the order sent by the board was inaccurate. The most common violations for a contractor are exempt with employees, lead-based paint violations, advertising without a license or advertising while your license is inactive, and then working without a license. The first and most biggest mistake that a contractor will make when they get a notice of intent is not responding at all or not responding timely. We have to receive that violation response form within 21 days, so it's in the best interest of the contractor to reach out to the compliance officer or make sure that their response form was received within 21 days. If it's not received within that timeline, it will be a default final order against the contractor. So it's important to be timely with understanding your notice response form. So once the CCB has sent the final order, the contractor would contact the collections officer and discuss payment arrangements for their civil penalty or other disciplinary actions that applied.
My name is Maggie Dennett, and I'm a collections officer for the CCB. So when a final order comes to me, I send out a letter, just like it's a collections letter, just advising them to contact me and set up a payment plan or pay in full. And after 30 days, if I haven't heard from them, another letter goes out. And then I allow an additional 10 days to pass, and then I call them. For some reason, have you not received my letters? So at that time, if I can get a hold of the contractor, then he at that time will just set up a payment plan or pay in full. So usually with contractors, when I send out my first collections letter stating that they owe, probably 2 out of 10 will not respond because they're not getting their mail or they're avoiding the issue. So when a contractor responds to my letters, they'll call me and they'll either set up a payment plan where they're paying a minimum amount a month, or they pay in full. So if I don't hear from the contractor and I've sent out 2 letters, then I will call them. I'll start calling them, and I'll leave them a couple messages, and then after that, if I don't hear back from them, then their file will go to the Department of Revenue.
If a violation remains unpaid, the Oregon Department of Revenue can take the debt out of the contractor's next tax return or garnish the contractor's wages.
They do have, if a contractor has an active license, CCB license, and it gets sent to a third party, then we suspend their license till paid in full. So this would be a way to keep your license active, set up a payment plan with me, and pay on time every month until it's paid in full. A lot of times if they make their payments every month in a timely manner and they're really trying, I can always delete the interest also. So that's kind of an incentive to, you know, pay your bill and be done with it. So one of the things that a contractor can do to make this process easier on themselves would be to contact me as soon as they get a letter from me, or contact the enforcement officer that has issued the fine, and try and resolve it as soon as possible. My advice to the contractors when they receive any kind of correspondence from our enforcement department is to respond. If they're not understanding what the fine is for, or if they feel they've taken care of it and they're still getting correspondence from us, they need to call us. If they set up any kind of payment plan and for some reason they're not getting statements and they feel that maybe it's gone away, or call us, because I'm sure unless they get a paid in full letter, it hasn't been resolved.